or it can be the migration or emergencies. Okay, so these are the factors, not only cause, but also these are the consequences of social inequities and discrimination which are prevalent in our country. According to the data, the census of 2011 says that the number of child laborers in India were 10.1 billion, of which 5.6 million were boys and 4.5 million were girls. And a total of 152 million children, 64 million girls, and 88 million boys were estimated to be in the child labor globally. So it's not the problem of India alone. Globally, we find the child labor, and almost 1 in 10 of all children worldwide are child laborers. And there are so many acts, there are so many regulations which have been framed to protect the interests of the children. And one of which is the Child Labor Prohibition and Regulations Act 1986, which has formed to regulate the provisions relating to the child labor practices in India. And the government made substantial changes in the provisions of the Act somewhere in the year 2016. And from therefore, a complete prohibition has been imposed on the employment of child labor. And who is a child? A child is nothing but a person who has not attained the age of 14 years. Now, the necessity of the act is very much prevalent everywhere in India, because basically ours is a agricultural sector is the primary sector, and in most of the children in their early ages they try to support their family. And moreover, there are children who are forced to work at young ages because of many family factors, because more number of members in the family, and unemployment, poverty, lack of education. So there are so many factors which contribute to the child labor working in our country. And moreover, the ILO, International Labour Organization, and the fundamental rights and the directive principles of the state policy, which are provided in the Constitution of India, made obligatory on the part of the state to ensure that the child labor are protected from the employers. Now, they were the acts which prohibited the employment of the children below the age of 14 years, and 15 years in certain specified employments. As such, there is no procedure laid down by the law. And moreover, when you see the Child Labor Prohibition and Regulations Act 1986, the Declaration of the Rights of the Child 1959 was adopted by the United Nations General Assembly. And the rights of the children were defined in that declaration for the first time. And the declaration was drafted by the JEB, and is also known as the Geneva Declaration of the Rights of the Child. And this was adopted from 1924 by the League of Nations, and then somewhere in the year 1959 by the United Nations as well. So what does the declaration include? The declaration says that the child must be provided with all means which are essential for the normal development. And if a child is found hungry or sick, he should be fed and nursed. And if the child is delinquent and backward, then he should be helped and recovered. And if a child is orphan or abandoned, then shelter should be provided. And in times of distress, relief must be provided to the children first. So the declaration also says that the children should be protected from every kind of exploitation, and also they must be made conscious of the fact that the talent they possess should be devoted to the service of their fellow men. And the International Convention on the Rights of the Child, 1989, is a human rights treaty which includes the rights of the children, which are related to civil, political, social, health, and cultural rights. A child is defined by the convention as a human being who is under the age of 18 years, unless the law applicable to the child specifies the different age. So generally, we consider 18 as the age of majority. Unless you attain the age of 18, you are considered as a minor. So the UN Convention has given the statement that a child who has not attained 18 years, unless proven in the act, unless specified in any particular act, will not be, will be considered as a child. And then, according to the Indian Indian Constitution, the rights are ensured to the citizen of the country. So the children also have the rights as per the Constitution, which has been stated by the country. And what are the rights? The right to free elementary education, which that was made compulsory under Article 21, and right to protection till the age of 14 years from any kind of hazardous employment. So it means that a child below the age of 14 years should not be employed by anyone. Article 39, the Constitution protects the child from any kind of abuse or forced employment, and this is not suitable according to their age or ability. And the children are also provided with equal opportunities like facilities, freedom, dignity, and protection under the Article 39 of the 39F of the Indian Constitution. And the Article 45 of the Constitution also ensures childhood care and education to the children until the age of 6 years. So besides the special provisions which are made under the Constitution, the children also have equal rights as like any other adult citizen of India. Now, what are the provisions, statutory provisions and child labor in India? So the first act, the Labor Act, Factories Act in the year 1981, which was enacted, was extended to the working children as well. So it set the minimum age of employment in the factories at 7 years and allowed a maximum of 9 hours of work per day. And it also provided at least 4 days holidays in a month and prohibited successive employment of child workers in 2 factories where the employment is more than of 100 workers. So these were the Factories Act 1881 have propounded. Now, based on the recommendations of 23rd session of the ILO, where a convention with a special article which is exclusively on India was adopted. So the government prohibited child work below 13 years of age in certain categories of employment, and the Employment of Children Act 1938 was also enacted. So what is the Employment of Children Act 1938? It was the first act which directly addressed the problems of child labor in India. The act prohibited child labor in the transport of passengers, mails by rail or goods, or in the handling of goods at docks, or but excluding the transport by hand. Excluding these, any other category of the transport was prohibited. And the Minimum Wages Act, which was passed in the year 1948, defines a child, a person who had not attained the 14 years of age, who has not completed, and the appropriate government fixed different rates of wages for the adults, for the adolescents, and for the children. And also they have specified the normal working hours for a child to be 4.5 hours. And no child could be employed or permitted to work overtime. And the Mines Act 1901, Indian Post Act 1931, the Tea Districts Emigrant of Labor Act 1932, Children Pledging of Labor Act 1933, Merchant Shipping Act 1958, Motor Transport Workers Act 1961, BD and Cigar Workers Conditions of Employment Act 1966. The Shops and Commercial Establishments are few acts in which the provisions to abolish and restrict the employment of children in the respective industries were included. But when it comes to the uniformity of the age, there is no uniformity of age which is defined and which is identified. So just now I said in the earlier cases 18 years, and then it was 15 years, and then 14 years. So there's no uniformity in the age which has actually defined like who is a child labor. So in the year 1961, the Apprentices Act was passed and prohibited the apprenticeship or training of a child below 14 years. So in the case of apprenticeship of other minors, a contract was required between the guardian and the employer. Likewise, the Bonded Labor Systems Abolition and Regulation Act 1976 abolished the bonded labor system. Every bonded labor, including child bonded labor, are freed and discharged from any obligation to render any bonded labor. So this is how the various acts have protected the child labor and the bonded laborers. Now, coming to the recommendations and observations of the commissions and the committees. So the Royal Commission on Labor 1931 that said that in many cities, a large number of young boys are employed for long hours and discipline is strict. And there was corporal punishment and other disciplinary measures were also, imposed on the young adults or young boys, and they are asked to work for 10 or 12 hours daily, and they did not provide adequate meals or the intervals for the rest, and the weekly rest days were also not followed. So the commission drew the attention towards this abuses and in connection with the child labor in workshops where the Factories Act did not apply. Okay. And the recommendations of the commission led to the enactment of Children Pledging of Labor Act 1933 and Employment of Children Act 1938. Okay, so the provisions we have already discussed, and the committee observed that the important fact that emerged from the investigation in various industries, and moreover, they have investigated in the smaller industries. The prohibition of the employment of children is disregarded quite openly. And owing to the inadequacy, there were so many child who were employed in these industries. So basically, if you see the stone breaking, carpet weaving, brick kilns, handicrafts, road building, cotton ginning and weaving, restaurants and hotels, small plantations, these are the places where the child labor have been employed. So, based upon which, what were the further recommendations or the commissions have done? So, they have enacted the National Policy for the Children, which has come into being in the year 1974. And it said that no child below the age of 14 years would be permitted to be engaged on dangerous work, or it can be heavy work. Okay. And children would also be protected against cruelty, exploitation, neglect. Okay. And we also have Committee on Child Labor, uh, Gurupada Swami Committee. Now, Gurupada Swami Committee, appointed by the Government of India in its report, which was submitted in the year 1979, recommended that the fixation of minimum age of entry to any establishment, strengthening the machinery, establishment of child labor advisory boards, formation of effective education policies, review the implementation of existing laws, and it has also suggested legislative and welfare measures for the working children. They also wanted to review the progress of welfare measures, okay, and wherein the Child Labor Prohibition and Regulation Act 1986 came into force. So, along with the developments taking place in the country, the child labor has also gained the global attention, and the ILO and the United Nations especially have formed so many resolutions to protect the child labor. So what are the objectives of this particular act? Again, prohibition of the child who has not attained the age of 14, prepare a procedure for changes in the schedule of banned jobs wherein the child cannot be hired, controlling the working conditions that do not prohibit children from working, and also enhancing the fines wherever the factories are not following, and get attractive in the definition of the child in related rules. So the act extends to whole of India, and as per this, the definitions appropriate government, it can be the central government, in case of major ports or mines or railways, oil fields, and in all other cases, it would be the state government. Child is a person who has not completed 14 years of age, a day, 24 hours, beginning at the midnight. Establishment, it includes a shop, commercial establishment, workshop, hotel, restaurant, eating house, theater, or any other place of public amusement or entertainment. And a family, it comprises of husband, wife, and children, brother or sister. Occupier is the person who actually occupies the workshop and who actually controls the affairs in the workshop. Port authority, administering a port. Prescribed, it is nothing but prescribed by the rules. Week, it's a 7 days period starting from the midnight on Saturday. Workshop, it's the premises where the industrial process is carried out. Prohibition of employment of children in certain occupations and processes. So the Child Labor Prohibition and Regulation Act 1986 aims to eradicate any kind of child abuse in the form of employment or in the form of engagement of the child in the hazardous employment who has not completed the age of 14 years. So occupations, they have been mentioned here. The occupations which are prohibited are mentioned in the Act, like occupations that are related to the transport of passengers, goods, or mails by rail, cinder picking, clearing of an ash pit, or building operation in the railway premises, working in a catering establishment which is situated at a railway station, occupation which involves work related to the construction of a railway station, any occupation within the limits of the port, working in slaughterhouses, and then the process involving making of BD, carpet weaving, bagging of the cement, cloth printing, dyeing, weaving, mica cutting and splitting, wool cleaning, slate pencils, construction industry, cashew nuts, descaling process. Okay, so these are the specific occupations, that is approximately 13 occupations with 51 processes for the employment of children. So Article 24 of the Indian Constitution includes the provisions for the prohibition of the employment of children in these factories. And a child who is not below above 14 years is not supposed to be employed, and no employer can force a child to work between 7 p.m. to 8 a.m. and never a child should be asked to work overtime, and definite interval of 1 hour is must for more than 3 hours of continuous work. And a child should be given a holiday, a paid holiday after every 6 days. And then adequate provision should be made for the health and safety of the child employees. And the power to amend the schedule, section 4, has the central government, after giving by notification in the official gazette, not less than 3 months notice should be given for any amendment in the schedule. And similarly, the Child Labor Technical Advisory Committee is there. The central government may, if it thinks it to be necessary, constitute an advisory committee to be called the Child Labor Technical Advisory Committee. And the committee shall consist of a chairman and such other members, not exceeding 10, and will be appointed by the central government. And the committee shall meet often and consider necessary, make procedures, regulate the procedures. And these are to be taken care by the committees or subcommittees which are appointed as per the prescribed law. Now, the regulation of the conditions of work of children, the Child Labor Prohibition Regulation Act 1986, it needs to follow while employing a child in the establishment that the proper working conditions are to be provided by the employer. The provisions of this part shall apply to an establishment or class of establishments in which none of the occupations or processes referred to in section 3 will be carried on. Now, coming to the section 7, where the hours and the period of work have been specified. So, no child will be permitted to work in excess of the number of hours prescribed as per the establishment. The period of work on each day shall be so fixed that no period shall exceed 3 hours without a break. And the period of work shall be so arranged that inclusive of his interval for rest, it shall not spread over more than 6 hours, including the time spent in waiting for the work on the day. And no child will be permitted to work between 7 p.m. to 8 a.m. No overtime to be given to the child. No child shall be required to permitted to work in any establishment on any day on which he has already been working in another establishment. And as I said, weekly holidays, a child is allowed to take 1 paid weekly holiday as per the norms. And every occupier in relation to the establishment in which a child was employed before the date of the commencement of this act in relation to such establishment has to provide the data within 30 days from such commencement sent to the inspector of the local limits where the establishment is situated. The notice should be in a written format and it should contain the name and the situation of the establishment, name of the person in actual management of the establishment, and the address to which the communications have to be sent and the nature of the occupation where the process is carried. And he has to also see that the establishment is following the stipulated rules which are mentioned about the child labor. And if there is any dispute as to the age, that is whether the child has attained 14 years or not, in the absence of the certificate of the age, so the child shall be granted the prescribed medical authority. So after examining by the medical authority, the age will be specified. And the maintenance of the register is must, the name, the date of birth of the children, number of hours and the period of work the child employee is doing, the nature of the employment, and other particulars which are required should be maintained in the register. And all the health and safety measures have to be taken care. The cleanliness of the workplace, it can be the disposal of waste, temperature, ventilation, dust, fume, artificial humidification, lighting, drinking water, spittoons, restrooms or washrooms. Okay, and eating near machinery, whether the flow stains, pits, sums, excessive weights, protection of the eyes, all these factors have to be taken care whenever the child is employed. And there are penalties which are levied if there's a failure of any of the provisions mentioned in the section 3. So it can be 10,000 rupees fine, which may extend up to 20,000 rupees, and also imprisonment from 3 years to, 3 months to 1 year. And moreover, there are modified applications of certain laws in relation to the penalties, where any person is found guilty and convicted of contravention of any of the provisions mentioned, he shall be liable to penalties and he will be also prosecuted. So the provisions are relating to this section 67, section 40, section 109, and section 21. And the procedures relating to the offense, any person, police officer or inspector may file a complaint of the commission of an offense under this act to the court under the jurisdiction. And every certificate as to age of the child which has been granted by the prescribed medical authority shall be the evidence. And no court inferior to the metropolitan magistrate or a magistrate of the first class shall try any offense under this act. So the appointment of the inspectors as per section 17 is made compulsory, and they have the power to make rules under section 18. And the rules which are pertaining to the child labor, the same rules they can verify. And any amendment should be, the rules and the notifications to be laid before the parliament or state legislature as per section 19. Every rule which is made by the government through any notification which is issued under section 3 shall be laid before the House of Parliament as soon as possible. Okay, so, and the parliament in a session for a period of 30 days, it will try to accept and which becomes a ruling. Okay, and we have the power to remove difficulties pertaining to any kind of difficulties arising with the notification in the official gazette published. The provisions can be removed after the expiry, and every order made under this section, as soon as maybe after it is made, will be laid before the Houses of Parliament. And moreover, we have the repeal and savings, and also the amendment of Act 11 of 1948. We have amendment of Act 69 of 1951, where the adolescent means a person who has completed his 14th year of age but has not completed his 18th year of age is considered as an adolescent. An adult who has completed the 18th year of age, and a child who has not completed the 14 years of age. So there are so many amendments which are made for the shipping company, for the transport company, and so on. And these amendments are to be followed by the factories. Now, coming to the next subheading, we have the Sexual Harassment of Women at Workplace, Prevention and Prohibition and Redressal Act 2013. So, when we see the current scenario, women are equally working with men. I mean, when you see the workforce, the composition of male and female, there is no discrimination. But the large women in the mainstream workforce of India face sexual harassment at workplace. And it can be in the form of gender discrimination, or it can be the fundamental right to the equality and right to life. So these were all given by the Constitution of India. So the workplace sexual harassment not only creates an insecure and hostile working environment for women, and also impedes their ability to deliver in today's competing world. So we have the POSH Act, which was enacted by the Ministry of Women and Child Development in the year 2013. So the prevention of sexual harassment in the work of women at workplace. So we have the redressal in 2013. We have the criminal law amendment, where it is also considered as a criminal offense against whenever a person is victimized with the stalking, or it can be the sexual harassment. And coming to the international legislative frameworks, so India's participation in the various international forums and the ratification of the international treaties on the human rights of women, it's a testimony of the commitment of our country to ensure the dignity and equality of women in all the spheres. So the following standards and frameworks are the key contents which are trying to promote equality and also addressing the sexual harassment. The first is the Universal Declaration of Human Rights, 1948, wherein Articles 1, 2, and 7 speak about equality in dignity, rights, and freedoms, and protection against any discrimination. The ILO discrimination, employment, and occupation, it aims to protect against discrimination in employment and occupation on the grounds of sex, race, color, religion, political opinion, nation, or social region. And International Covenant on Economic, Social, and Cultural Rights, it enjoins, all states to guarantee rights enunciated in it without any discrimination of any kind. So states must ensure that there is equality between women and men for the enjoyment of all economic, social, and cultural rights which have been established in the Covenant. The United Nations Conventions on the Elimination of all forms of discrimination against women, which is categorized under Article 11, and ILO, Indigenous and Tribal Peoples Convention 1989, government shall, within the framework of national laws and regulations, and in cooperation with peoples concerned, adopt special measures to ensure that workers enjoy equal opportunities as well as the equal treatment in the employment for women and men, and also protection from sexual harassment. So ILO Decent Work for Domestic Workers Convention 2011, each member shall take measures to ensure the domestic workers enjoy effective protection against all forms of abuse, harassment, as well as violence. And we have also a resolution on equal opportunities and equal treatment for men and women in the employment, and also the UN Declaration on the Elimination of Violence Against Women, 1993. So violence against women as any act of gender-based violence that results in physical, sexual, or psychological harm or suffering to women, including it can be the threats of such acts, coercion, or it can be arbitrary deprivation of liberty, whether occurring in public or private life. And we also have the Beijing Platform of Action, which has drawn the attention of the United Nations Women's Conference in Beijing. It called to advance women's rights and to eliminate violence against women, including sexual harassment at work. And ILO, HIV, and AIDS recommendation, measures should be taken in through the workplace to reduce the transmission of HIV and the impact by ensuring actions to prevent and prohibit violence and harassment in the workplace as per Article 14. So we have so many national legislation frameworks. So in India, the Vishaka guidelines was the first ever legal action that provided a broad framework for preventing and addressing cases of sexual harassment of women within the workplace. So this Vishaka guidelines, it became very popular, and it is a very popular directive where the state government has taken a stance against the judgment. Okay, and the workplace sexual harassment, wherein the Supreme Court has given a landmark judgment of Vishaka. So actually, the Vishaka judgment came in the year 1992, where Banwari Devi, a Dalit woman, she was employed with the Rural Development Program of the government of Rajasthan, and she was brutally gang raped on the account of her efforts to curb then prevalent the practice of child marriage. So the incident revealed the hazards that working women were exposed to on day-to-day basis, and highlighted the urgency of safeguard to be implemented in this regard. So this is how the Supreme Court for the first time acknowledged the glaring legislative inadequacy and acknowledged the workplace. Yeah, can you please put your mic on mute, whoever it is? So in framing the Vishaka guidelines, the Supreme Court placed a reliance on the Convention on Elimination of All Forms of Discrimination Against Women, adopted by the General Assembly of the United Nations. So as per the Vishaka judgment, sexual harassment includes physical contact and advances, a demand or request for sexual favors, sexually colored remarks showing pornography, or any other unwelcome physical, verbal, or non-verbal conduct of sexual nature. So all these are considered as sexual harassment under the judgment of Vishaka. Now, post Vishaka, there are some other judgments also where Apparel Export Promotion Council and A.K. Chopra, where the sexual harassment has been, the Apparel Export Promotion Council was found guilty of sexually harassing a subordinate female employee. And we have so many other cases which have been came into light, wherein the women have been sexually harassed at the workplace, and based on the Vishaka guidelines, which have led to amendments in the existing laws for the government and the industrial establishment having more than 50 employees to include prohibition of sexual harassment, that is POSH. Prohibition of Sexual Harassment in the Workplace is nothing but the POSH Act, which has been enacted in the year 2013. So we have again the prominent cases where the Constitution of India and also the states that sexual harassment in the workplace is a violation of the fundamental right to the gender equality and right to life and liberty. So there are so many cases. These are the cases where it was identified that how women are being sexually harassed at workplace and what kind of law or the amendments were made to protect the interest of the woman. And then we also have enactment of Sexual Harassment of Women at Workplace, Prevention and Prohibition and Redressal Act 2013. So the POSH Act has been formed in the year 2013 to provide protection against sexual harassment for women at workplace. And the prevention and redressal of complaints of sexual harassment for matters connected were also considered very, very important. And this act was applicable to whole, extends to whole of India, and it came into force in 2013, and it shall come into force such date as the central government by notification in the official gazette appoints. Who is an aggrieved woman in relation to a workplace, a woman of any age, whether employed or not, who alleges to have been subjected to any act of sexual harassment by the respondent. Appropriate government, it can be the central government, or it can be any other case, the state government. The chairperson is the person who actually takes the complaints, and committee nominated is called as a chairperson. The district officer means an officer who has been notified under Section 5, domestic worker, or woman who is employed to do the household chores or household work for a remuneration. Employee is a person who actually employ the workers or employees for getting the work done. And the employee means a person who actually works for the employer. And then internal complaints committee constituted under section 4. You also have local committee, local complaints committee constituted under section 6. Member means a member of the internal committee prescribed as per the rules. Presiding officer of the internal complaints committee who has been nominated under subsection. Respondent means a person against whom the agreed woman has made a complaint. Sexual harassment, as we have already discussed, it can be physical advances, favors, sexual remarks, or unwelcome physical or verbal, non-verbal conduct of sexual nature. Workplace, where a place the employee and it's an establishment where employees come and work. Unorganized sector, owned by the individuals or self-employed workers and engaged in the production and sale of goods. Now, sexual harassment, it can be defined on the basis of sex that has the purpose of effect of substantially interfering with the person's work performance or creating an intimidating, hostile, or offensive work environment. So here, the submission can be a rejection. It can be either explicit or implicit. So any form can be considered as a sexual harassment. There are 3 forms of sexual harassment. Quid pro quo means you benefit something, I benefit something. It is a form of sexual harassment. Hostile environment created by the supervisors and offensive working environment, or hostile environment created by the co-workers or non-employees. I mean, it cannot be considered as a direct harassment by the supervisors, but the employees and the co-workers or even the employers' customers. Now, the objectives of the Act is to develop and implement a policy of prevention of sexual harassment at the workplace, to evolve a permanent mechanism for the prevention and redressal of sexual harassment, and to follow and implement the Act, enjoining all employers to constitute an internal complaints committee. So no woman shall be subjected to sexual harassment at workplace, and implied or explicit promise, preferential treatment, detrimental treatment, or it can be threat, or it can be creating intimidating or offensive or hostile work environment, and which usually affects our health and safety. So the constitution of internal complaints committee, I mean, you need to have an internal complaints committee, local complaints committee, wherein they try to take the complaints and act appropriately. Every employer of a workplace shall by an order in writing constitute a committee to be known as internal complaints committee, and this committee will be having a presiding officer who shall be a woman employed at a senior level, and not less than 2 members amongst the employees, preferably committed to the cause of women, and 1 member from non-governmental organization should be the part of the committee. And the local complaints, so the appropriate government may notify a district magistrate or additional district magistrate or a collector of a deputy collector to exercise the powers. And constitution and the jurisdiction is maintained, and they shall constitute in the district concerned, and the district officer shall designate 1 nodal officer in every block or taluka and tehsil in the rural and the tribal area, so that they, if any complaint is received, which can be acted within a period of 7 days, and the jurisdiction of the local committee shall also extend to the areas of the district where it is constituted. Now, the composition, a chairperson would be nominated, and as I said, it should be a woman, and 1 member of the nominated from the amongst the women working in the block or taluka. And the 2 members, at least 1 shall be a woman. So they provide they try to collect the background, and the concerned officer, it can be the social welfare or women or the child development in the district or ex officio. So, and the chairperson and the member of the local committee shall hold the office for such period not exceeding 3 years. And once the chairperson receives the complaint, it is the duty of the chairperson to take care of the complaint and do the provide justice to that particular complaint. And the chairperson or the members of the local committee, other than the members nominated, shall be entitled to such fees or allowances for holding the proceedings of the local committee as may be prescribed. So, payments and the accounts of the agency referred shall be maintained and audited in such manner as prescribed. So, coming to the complaint mechanism, lodging a complaint against sexual harassment is an important crucial activity. So, once the aggrieved woman make a complaint in writing to the workplace internal committee. So the committee will call for a meeting with the chairperson and the members of the local committee, and they try to provide the assistance. And once the committee has received the complaint, the reasons will be recorded in writing and within the prescribed time, not exceeding 3 months. And then they make a conciliation where the process to settle the matter is initiated between the parties. And then the inquiry into the complaint is also done where the summons were sent to the person for examination for the attendance and also for the oath taking, and the production of the evidences or the documents will be taken care. And once that is done, the action will be taken. So, action during pendency of inquiry, when any inquiry is going on, transfer the aggrieved woman or the respondent to any other workplace, or grant leave to the aggrieved woman for a period of 3 months, or grant such other relief to the aggrieved woman as may be prescribed. Now, once the inquiry report is done by the internal committee or the local committee or whatever the case may be, and it will try to take the action for the sexual harassment, and the action will be as per the rules and norms. So, punishment for false or malicious complaint and false evidence, and even here, whenever there's a false complaint or a malicious complaint, so there is a punishment for such kind of crimes as well. And determination of compensation whenever there is a sexual harassment, the mental trauma, the pain, the suffering, and the emotional distress, the loss of opportunity in the career, and the feasibility of the financial status, all these will be taken into criteria, and then the compensation will be determined. And prohibition of publication or making known consents of the inquiry or the complaint is prohibited. And there's also penalty when such thing has been published. And within 90 days, an appeal can also be made for such kind of penalty. So the duties of the employer is to take care of the women employees properly and maintain, organize workshops and arrange programs wherein they try to discuss the things about the sexual harassment and provide information. So in a way, they have to provide information that anything against the woman is done, there's a severe action to be taken. So, and the district officer, time and time, they have to verify and submit the report to the local committee, and the committee is also submit the annual report with what all the complaints they have received and the kind of actions they have taken. And employer should also include such information in his annual report. And the appropriate government should monitor and try to see that the implementation and the maintenance of the data is done. And moreover, the act should be publicized about the punishment and the various penalties or fines which are levied against the employees. And the penalty for the non-compliance will be 50,000 penalty, or it can be the imprisonment as well. So such kind of punishment should be there, which should be by law to be implemented in the organizations where they can prevent such kind of acts. And the appropriate authority have power to make rules and amend the rules. And the equal opportunities laws, criminal laws, tort laws, and labor laws, all these laws try to protect the women against the sexual harassment. And they are, broadly speaking, two types of remedies and two types of sanctions for the sexual harassment. The first one would be the money for the damages, or the monetary relief can be given. And it can also be awarded immaterial damages, which can be the legal system, as moral damages or compensatory damages can also be given. So in a way, you try to protect the interest of the woman by the various constitutional provisions and articles which have been provided to protect the woman. And the legal provisions for working women, we have IPC, we have the Factories Act 1948, we have the Maternity Benefit Act 1961, and we also have the Equal Remuneration Act, which all take into the criteria in protecting the women employees in the organization. And coming to the last criteria, we have the Information Technology Act 2000. Now, what is this Information Technology Act? So, computers and internet have positively impacted the entire society. We have large data, huge data, and most of the work is going to be done through computers or through the internet modem. So, you need to have some kind of an act which tries to protect people or companies from the unauthorized usage of the data. So due to globalization, the technical changes have occurred in all types of industries. Information technology, irrespective of their designation, is moving directly and indirectly. So information technology has become a part of the personal and professional life. And whenever we are using IT at workplace, we need to understand that the IT has to take right and proper action against the personnel. So here, the Information Technology Act 2000, coming to the objectives, to provide legal recognition to the transactions done via electronic exchange of data or other electronic means of communication or electronic commerce transactions. So they have to provide the legal recognition for the digital signatories, digital transactions, facilitate the electronic filing of the documents, facilitate the electronic storage of the data, give legal sanction and also facilitate electronic transfer, grant legal recognition. Okay, so there are so many objectives of the IT Act. So the structure, it has totally 13 chapters and 90 sections. Basically, they try to provide the rules and regulations for the following of the Information Technology Act. Now, this act has been amended in the year 2008. Now, as per this, the definitions, if we see, access, it is a grammatical variation and cognate expression means gaining entry into instructing or communicating with the logical, arithmetical, or memory function of a computer. Addressee means a person who is intended by the originator to receive the electronic record. Affixing, it is electronic signature. Communication device means cell phones. Digital assistants or combination of both. Computer system means a device or collection of devices which includes input and output support systems. Cyber cafe, which means the facility from where access to the internet is offered by any person in the ordinary course of business. Cyber security means protecting the information, equipment, devices, computer or computer resources. Data means the information. Digital signature is the authentication of any electronic record by the subscriber. Electronic record means the data record or data generated. Electronic signature, authentication of electronic record by a subscriber. Information includes images, sound, voice, codes. Originator means the person who sends. Private key means the key of a key pair used to create a digital signature. Public key means the key of a key pair used to verify the digital signature and listed in the digital signature certificate. Secure system, where the computer hardware, software, and procedure are reasonably secure from unauthorized access. So you have the subscriber means a person whose name is electronic signature certificate is issued. Security procedure is the procedure which is prescribed under Section 16 by the central government. Now, digital signature, it is defined under Information Technology Amendment Act 2008. So, which is the digital signature is an authentication of an electronic record. So, and the use of the public key, infrastructure, and hash function, etc. So, this is what is done whenever we receive any mails from mobile or any other company, we find the digital signature. So, it is the authorized signature by the company. So, e-governance under the IT Act, legal recognition of record where any law requires that any information should be in the type of a written or printed form, then such requirement shall be deemed to be satisfied that if it is in an electronic form. So, legal recognition of electronic signatures is mandatory. Use of electronic records and electronic signatures in the governments and its agencies. wherein whenever we receive any kind of a document from the government agencies as well, we find a digital signature. And the delivery of the services by service provider. So for the purpose of e-governance and for efficient delivery of services to public through electronic means. So what does the appropriate government do by notification in the official gazette? Authorize that any service provided to the setup, maintain and perform such other services as it may be specified. And retention of the electronic records, whatever the records, the documents or the information which has been retained for any specified period shall be deemed to have been retained if the same is retained in the electronic form, provided the following conditions are satisfied. So the information remains accessible so as to be usable subsequently, and the electronic record is retained in the original format, and the detail which will facilitate the identification of the origin. So the audit of the documents maintained in the electronic form is mandate. Every document has to be audited. Publication of the rule and regulation in the electronic gazette, where any law provides that any rule, regulation, order, bylaw, notification, or any other matter shall be published in the official gazette, then such requirements shall be deemed to be have been satisfied. And no right to insist government office to interact in electronic form. So there's no right conferred upon any person to insist any ministry of department of central government or state government or any authority to interact in the electronic form. And the power to make rules by the central government in respect of electronic signature are prescribed in the form of electronic signature, the manner and the format in which the electronic signature should be affixed, the manner which facilitates the identification of the person, control processes and procedures, or any other matter. So all this is taken care by the central government by enactments. The electronic record shall be attributed to the originator. So if it was sent by the originator himself, by the person who had the authority to send, or by any information system programmed. Okay, and once you receive the acknowledgement of the receipt, where the originator has not stipulated that the acknowledgement of receipt of electronic record be given in a particular form, then the acknowledgement may be any communication by the addressee, automated or otherwise. Any conduct of the addressee sufficient to indicate that the originator, that the electronic record has been received. And where the originator has not stipulated that the electronic record shall be binding only on the receipt of such acknowledgement, the acknowledgement has not been received by the originator within the time specified or agreed. If no time has been specified or agreed within a reasonable time, when the originator may give a notice to the addressee stating that there is no acknowledgement received. And time and place of dispatch and receipt of electronic record. Save as, agreed between the originator and the addressee, the dispatch of an electronic record occurs when it enters the computer resource. And save as otherwise agreed between the originator and the addressee, the time of receipt of an electronic record shall be determined as follows. If the addressee has designated a computer resource for the purpose of receiving the electronic data, if the electronic record is sent by the computer source by the SSC that is not designated the computer resource, and if the addressee has not designated a computer resource along with the specified timings. And otherwise agreed between the originator and the addressee, the electronic record is deemed to be dispatched at the place where the originator has his place of business. And we also have, for the purposes of this section, if the originator or the addressee has more than one place of business, the principal place of the business shall be called as the place of business. And if the originator or the addressee does not have any place of business, his usual place of residence shall be deemed to be the place of business. Usual place of residence in relation to a body corporate means the place where it is registered. Now, coming to the secure of the electronic data, where any security procedure has been applied to an electronic record at a specific point of time, such record shall be deemed to be a secure electronic record. And what is secure electronic signature? The signature is deemed to be a secure electronic signature if the signature contains data at the time of affixing the signature. was under the exclusive control of signatory and no other person. And the signature creation data was stored and affixed. So in such exclusive manner as may be prescribed. So the security procedures and practices, the central government, as per section 14 and 15, prescribed the security procedures and practices, provided that in prescribing such procedures and practices. So how do you secure digital signature, which has been specified in section 15? Unique to the subscriber affixing it, capable of identifying such subscriber. So whenever your digital signature is there, that should be unique and it should be capable of identifying such subscriber and created in a manner or using a means under the exclusive control of the subscriber. You need to have total control of the usage of the digital signature. So your digital ID is trusted. Certificate based on the digital IDs come from accredited providers, and it all gets encrypted. Your digital signature and the document you sign are encrypted together and bound with a tamper evident seal. It's unique to you. Every time you sign a document, you use your own unique digital certificate and PIN to validate your credentials. And it is very easy to validate. Both the signed document and the digital signature can be revalidated by a CA or TSP. And this is the period for up to 10 years after signing the event. And difference between the digital signatures and the electronic signatures or e-signatures refer broadly to an electronic process that indicates acceptance of an agreement or a record. And digital signature is frequently used to refer to one specific type of electronic signature. Typical electronic signatures, they use common electronic authentication methods to verify corporate ID, phone PIN, such things. The best e-signature solutions demonstrate proof of signing using a secure process that includes an audit trail or it can be a final document. Digital signatures use a specific type of electronic signature and they use a certificate-based digital ID to authenticate, signer, identify and demonstrate the proof. Signature types are linked with signature laws and regulatory requirements. Now, certifying the digital signatures. So the Office of the Controller of Certifying Authorities issues certificate only to the certifying authorities. So the certifying authorities in turn issue digital signature certificates to the end users. So one can approach any of the certifying authorities for getting the digital signature certificate. So certifying authorities is a trusted third party willing to verify the ID of the entities and their association with some given key and later issues a certificate attesting to the identity. And coming to the this digital signature can be revoked when an officer is transferred or suspended or his or her key is compromised. So CAs and their websites, we have these are the websites who have the certifying authorities who can provide the digital signatures. And certifying authority to issue electronic signature certificate, any person can make an application to the certifying authority for the issue of an electronic signature certificate as prescribed by the central government, and every such application shall be accompanied by a fees not exceeding 25,000 rupees as may be prescribed by the central government, and every such application shall be accompanied by a certification practice statement. Where there is no such statement, a statement containing the particulars may be specified. And on receipt of the application, the certifying authority may, after consideration of the certification practice statement, may provide the digital signature, or no application shall be rejected unless the applicant has been given reasonable opportunity of being heard. Coming to the other provisions relating to the issue of digital signature, representations upon issuance of the digital signature, the subscriber holds the private key corresponding to the public key listed in the digital signature. The subscriber's public key and private key constitute a functioning key pair, and the information contained in the digital signature certificate is accurate. So the suspension of digital signature certificate can also happen on receipt of the effect from the subscriber listed in the digital signature certificate, and any person duly authorized to act on behalf of that subscriber or the digital signature certificate should be suspended in public interest, or the digital signature certificate shall not be suspended for a period exceeding 15 days unless the subscriber has given an opportunity of being heard. So revocation of digital signature certificate, this can also happen upon the death of the subscriber, upon the dissolution of the firm, or the subscriber or any other person authorized by him makes a request to that particular effect. Okay, and the notice of suspension or revocation should be the authority shall publish a notice of such suspension or revocation in the information bureau, and such notice will be given under section 37 or section 38. Now the penalties, so they are penalties which are levied against any willful disruption of the data, the damages or disrupts or provides any assistance or charges the services availed, destroys or deletes or alters any information, steal, conceal or destroy or alters any other information. For all this, he shall be liable to pay the damages by way of compensation to the person so affected. So the compensation can be the compensation for failure to promote the data, pay the damages by way of compensation which was affected by the party. You also have a penalty for failure to furnish the information and the return, etc. That can be up to penalty up to 1,50,000 rupees. And if you're failing to file a return or furnish the information, he shall be liable to a penalty not exceeding 5,000 rupees. And residuary penalty, whoever contravenes any rules or regulations made under this act of the contravention, a fine, there is a compensation amounting to rupees 25,000 rupees should be paid to the person. And they are also power to adjudicate for any adjudication chapter whether any person has committed a contravention of any of the provisions, regulation or direction can be proved under this adjudication. And factors to be taken into account by the adjudicating officer, the amount of gain of unfair advantage and the amount of loss caused by any person will be the major causes. And tampering with computer source documents, you tamper any computer source documents, a fine up to rupees 2 lakhs will be levied, and an imprisonment up to 3 years might also be levied. And the punishment for dishonestly receiving the stolen computer resource information, fine up to rupees 1 lakh, and imprisonment up to 3 years. Punishment for identity of the theft, so the fine might be up to 1 lakh rupees and 3 years of imprisonment. For cheating or personation by using computer resource, again fine up to 1 lakh or 3 years and 3 years imprisonment. Punishment for violation of privacy, 3 years imprisonment or fine not exceeding rupees 2 lakhs. And punishment for cyber terrorism, and any kind of cyber terrorism, denying or access to the person's authorized data, or attempting or penetrate to access the computer source willfully, or doing it to violate some kind of or to infuse some kind of terrorism shall be punishable with imprisonment, which may extend to life imprisonment. And punishment for publication, transmitting obscene material, up to 5 years imprisonment, and the fine up to rupees 10 lakhs. Punishment for publication and transmitting material containing sexually explicit act electronic form, up to rupees 10 lakhs fine might be levied, and punishment up to 7 years. And publishes any kind of the data which is relating to children in sexually explicit format, 10 lakh rupees fine, and imprisonment up to 5 years. And you also have power of the controllers to give the directions pertaining to this, and to also the power to authorize, to monitor and collect the traffic data or information through any computer resource for the cyber security. They have the power. And the appropriate government by notification in the official gazette declare any computer resource which is directly or indirectly affects the facility of the critical information infrastructure as protected system. And the penalty for misrepresentation, it might be imprisonment as well as a fine up to rupees 1 lakh. So these are the different kinds of penalties which are levied against the cyber crimes. And there's also confiscation, where the authority has the right to confiscate the computer floppies, disks, drives, and any material access to the computer which is not appropriate. And the central government to notify the examiner of these electronic evidences. The central government will appoint the person to justify the testament, and also the police officer and other officers to enter and search and confiscate the material evidences. Such powers have also been given to the police officers. So this is what all about the cyber security. I think I already exceeded the time, so I'm done with the syllabus. Thank you, students.